Good morning, friends. I hope you all are doing well. Now, since due to some unavoidable circumstances, it is not possible to deliver the lecture in the class. And considering the problem that is till today, we are not aware whether the exams is going to be conducted in regular manner or some other orthodox manner. In order to avoid the confusions, tensions in the minds of the students, let us start the study. Today we are going to study the topic from the CRPC. You are aware that the till today we have discussed the CRPC, that is up to the jurisdiction of the criminal courts, that is up to section 189. Now, of course, after the topic of jurisdiction, the next chapter is the charge. But before discussing the charge, we'll discuss the most important chapters from the CRPC, that is the trial. And the first trial which we are going to discuss, that is the session trial. The provisions of session trials are provided under section 225 to section 237. Before we are going to discuss the provisions of CRPC, that is the session trial, I know because of the gap and holidays, the problem of laziness is there. You are not aware what was we are discussed earlier. Let us discuss what is the provisions before we discussing the schedule 1. Now, as we are discussing in the class, suppose a lady or the person went to the police station, and the main hero of the CRPC that we have already discussed, that is the constable, before whom he or she deposed the offense or the things which has been done. And if the person, that is the constable, he realize, or what is the expected to the CRPC, that the officer in charge of the police station realize that there is something that is we call as the cognizable, then the police officer will register the FIR. This particular aspect we have discussed under section 154. We have already discussed what is meaning of FIR, especially the provisions of section 154, subclause 1, subclause 2, and subclause 3. If the FIR is registered, it is a mandatory duty of the officer in charge of the police station that the contents of the information has to be registered. It is to be write down. It has to be read over. It has to be explained to the person, and the gist of the FIR, gist of the particular deposition has to be recorded in the book kept in the police station. We call it the police diary. Once this contents has been registered, the copy has to be handed over to the informant. These are the mandatory provisions section 154. Now we are just discussing the background in order to understand the trial. Once the FIR is registered, then directly the provisions of section 157 came into picture. We call it the power of the police officer to investigation. Now, what is meaning of investigation? That is provided from 157 to 173. That is up to the filing of the charge sheet. Now, let us discuss. Now, the information. So, in order to understand the session trial, let us discuss that. Rather, we have discussed this example earlier also. Two people, they are going to the morning walk, and they found there is a dead body lying on the forest, on the land in the forest. Accordingly accordingly they call to the police, because the basic principle of criminal law say anyone can set the law in motion. So accordingly they call the police visit the spot. Now yet section 154 is not came into picture. Simply visiting the spot is not an investigation. That is something different that we'll discuss later on. Now the police officer came there, and after that, the first step the police officer is Again, they have done that is they have made an entry in the register kept in the police station, and accordingly, body sent for the identification for the medical to the hospital. That is, we call it the government hospital. Now, the next stage initiated by the police officer, because it is the informant, they are not aware with who is the person who is dead, and therefore the next procedure that is not mentioned in the CRPC, but that is the procedure provided under the police manual. They broadcast the message to all the police station that certain kinds of body they have found, and whether someone has lost the missing complaint or can anyone is identified the body. Fortunately for police stations, let us take the example. Fortunately, a person or the family member of the deceased, they approached the police station stating that yes, or directly the police officer, one of the police. Let us take the example. Suppose the police officer found the body in Pimpri station, police station area, and after the broadcasting, they received the call from the say the Sargate police station area that yes, 3 days back, they'll to their police station there is missing complaint lodged, and the the description of the body, description of the person is similar to the missing complaint. Accordingly, the Swargate police station called the parents or the family members from the informant. They went to the government hospital. They identified the body. Now, the moment it is this particular initial work has been done, then CRPC came into picture again. That is we call it the investigation. Now, after this, either the police officer, that is the constable, or any police officer of the police station, he lost the FIR, and he started recording the statement of the witnesses. Say for instance, the person who lost the missing complaint, either the mother, wife, brother, or whomsoever it may be from his family, his statement or her statement has been recorded by the police station. And while recording the police station, that is we call it the investigation. Interrogation is something different than the investigation. We have already discussed. Now the family member says, yes, 3 days back, or suppose 8 days back, there was a quarrel between deceased person and one Mr. X. Accordingly, the police approached to the house of the X, and they arrested the accused person. Now the moment police arrested the accused person, another chapter came into picture. Of course, that chapter we already discussed. That is we call as the the provision for the production of the accused person after the arrest. The first section came into picture in this respect. That is, you should take into record section 167. That is we call it the procedure when investigation is not completed within 24 hours. Now, what is the duty? The duty is provided under that section itself. Now, I'm sorry, this is not 164. That is 167. Now, it is the duty of the police officer, and we have already discussed either it in section 57 or the next section which we are going to discuss here, that the police officer or the person arrested should not be detained more than the 24 hours. Now, what is his duty? His duty is to take the accused person after the arrest. Of course, the another function is the police officer that he should send the accused person first to the medical, and then for the after the medical he has to produce the accused person to the magistrate. And when the police officer produces the accused person before the magistrate, he has to satisfy the magistrate that he requires the further police custody for the investigation. Now, the section 167 itself prescribedly provides the maximum police custody which should be granted by the magistrate is the 15 days. This particular aspect also we have already discussed. If, for instance, the police officer granted 6 days police custody. Now, this is police custody is granted for the investigation. Now, police officer may interrogate. Now, what is this interrogation? Now, interrogation is something if the accused person is not accepting the guilt. Now, this is something against the constitutional provisions, the constitutional guidelines provided to the accused person. But these are the powers of the police officer. So, the moment interrogation started, and during the course of the investigation or interrogation, accused person said to police officer, don't beat me, don't use the third degree. Now I will depose. Now the moment accused person is ready to confess, Now we have already discussed the importance of the confessions and the evidence of values of confession in last year under the Evidence Act, especially section 24, 25, 26 and 27, part 1 of the section 27. And therefore, if the police officer is very smart, he said, yes, gentlemen, even though you are accepting the guilt, you take a pause here. Whatever you want to say, you come with me and you depose magistrate. What for this we call as the judicial confession, which is to be recorded under section 164. Already we have discussed the procedure for recording the judicial confession. Now, this judicial confession has been recorded by the police officer. As per the CRPC, this particular aspect, this particular judicial confession has to be attached to the document we call as the charge sheet. Now, the statement of the informant is recorded, statement of the deceased friend, family member, his medical examination, his viscera report, the person who has, that is the doctor who has carried out the uh, what do you call the medical certificate, the postmortem. All these documents has been collected by the police officer, and ultimately this bunch of document we call as the charge sheet, that is under section 173 subclause 2. Now, even though last 10 minutes we are discussing initial procedure, this is just to understand or to refresh your memory. Yet we are not touched to the criminal trial, that is called a session trial. Now, after completion of the charge sheet, please bear in the mind, most of the students they are confused on this point, because right from beginning we have focused the schedule 1, and in schedule 1 especially 5 and 6 column deals with the offense and triable by the court. Now, this is the offense of murder we call as section 302. If you go through the schedule 1, it says it's a triable by the session. Why? Because the punishment criteria. Even though offense is triable by the session or whatever the court may be, till the judicial magistrate first class is the first instant court of the criminal, that is under the CIPC. This has to be underlined by all the students. And therefore, right from first day of production till the filing of the charge sheet, all the aspect has been done by the judicial magistrate first class. This is what we have already discussed, including one of the interesting aspect we have discussed, that is the power to grant the bail we call as default bail under section 167. That provision we have already discussed, but just to refresh your memory, if the accused person is arrested and after the 14 or 15 days of the police custody, if the magistrate has granted the police magistrate custody to the accused person, and and the accused bail has not been granted by the session court, that is we call as regular bail, and accused in jail, then the provision subsection 167 subclause 3 came, that is 2 came into picture. That is, if the investigation is not completed within 60 or 90 days, depends upon the punishment, then the accused person has a right to file an application for that is we call a default bail application. That application has to be filed before the magistrate. This is the only section which gives the power to the magistrate. Even the offence is triable by the session court, the magistrate has the power to grant the bail. The other powers of the bail, that is either anticipatory bail or regular bail for the offence is triable by the session court, that is exclusively dealt by the high court or the session court. But this is the special power with the magistrate. Now come back to the again. Now the office, that is accused person is not in jail, he has granted the bail by the regular bail by the session court under section 439, and he is out of jail. The charge sheet is on file. Now after filing of the charge sheet, now this is the opening door of the session trial. After filing of the charge sheet, it is the duty of the magistrate. Now the first duty we call as to see the compliance of section 207. Compliance of section 207, this is the first stage of the session trial. Now what is in this compliance of section 207? It is a mandatory duty of the magistrate to see that all the documents which has been collected by the investigation officer during the investigation, we call a charge sheet, or subsequent document after the completion time. Because under section 173 subclause A, the power of the police officer is that they can investigate the matter even after filing of the charge sheet also, subject to the permission from the magistrate. So under section 207, it is the duty of the magistrate to see whether there is a compliance of all the documents to the accused person or not. And therefore, once the compliance of section 207 is there, Then the next step came into picture, that too before the magistrate again, that the magistrate to see, that is we call as the committal of the case. That is under section 209. Now what is this committal of the case? Since the offence is triable by the session court, it is the duty of the magistrate to commit the matter. Committal, in other words, that this is just to transfer the matter to the session trial to the session court. The magistrate under section 209 may call the accused person if he is on the bail, or if he is in jail, he may ask the jail authority to produce the accused person before the magistrate. And on that day, when the accused person is produced before the magistrate, he has to ask the accused person. Of course, this is not the plea. This is not the plea of guilt, but he has to ask the accused person. Now, Mr. Accused, now the officer has investigated the matter. You are not discharged under section 169. We have already discussed. Now the police officer has succeeded to file the charge sheet against you under section 302. And if there are more of you, then read with section 34 of IPC. I hope you understand. And now, from next day, you have to attend the session court. What do you want to say? Now here, this is a trick, because the power under section 209, even though it is restricted, but it has its own importance. Now most of the students, they are confused between this section 209 and the judicial confession. Let us take the example for point of view. Suppose while that is the committal offense, if the magistrate says yes, now do you want to plead or what do you want to say, and if the accused person say yes sir, why you are committing the matter to the session court? I am accepting my guilt here before you only. Now see the section 164, that is deal with the judicial confession. But sometimes question is whether this kind of confession given by the accused person will be called as a judicial confession. The answer is yes or no also. When it is yes, when the magistrate has recorded the confession as per the provision of section 164. But if the magistrate has simply recorded the statement in the manner that when I ask the question for the committal, the accused has accepted the guilt, that is not a judicial confession. This is just on procedural formalities. But if the accused says, no sir, I am not accepting the guilt, I want to face the trial, then the magistrate, by recording the statement in this behalf, send the matter to the session court. Now this is just a background. This is just a background of how the matter come to the session court, and everything is based upon the schedule 1. Now let us go to the session trial. As I have already told you, section 225 to section 237 deals with the session trial. Of course, 36 and 37 deal with the other aspect, but up to section 235, that is we call as the session trial. Before we discuss what is section 225 to 26 to 26, 7 and all these aspects, let us discuss how this came into picture. Session trial, and where it is fixed that which trial has to be dealt by the session court and which trial has to deal by the judicial magistrate first class or the second class. The answer, because there are two types of trials so far as CRPC is concerned. I'm not talking about the different trials by the different courts, but the initial two types, that the trial conducted by the magistrate and trial conducted by the session court. Please bear in the mind, Supreme Court and High Courts, they have nothing to do with the trials. These two courts are deal with the trials. Now where it is fixed which court will decide which matter, the answer is again that is the schedule 1, especially the part 2 of the schedule 1 and column 1st of the schedule 1. The list of the offences is provided, and which offences? These are the offences from the IPC, which start from section 107 to the last offence of the IPC, that is section the 506 or sometimes 509 also. Now once this is done, if the second part of the schedule 1 deals with the specific provisions of the offences, and it specifically provided that the offence is triable by the session court, that matter will be dealt by the session court. If it is specifically provided the offence is dealt by the magistrate court, then it is by the judicial magistrate first class. Now so far as the punishment criteria is concerned, along with the session trial, you should write one section that is most important, section 4, subclause 2 of the CRPC. This is the general principle which deals with. Now you should understand this. Section 4, subclause 2. What is this? If you read this, it simply says the offense which are punishable with the imprisonment of life or imprisonment for more than 7 years. I'm again reading. Imprisonment for life, death sentence, or imprisonment for more than 7 years. Those offenses by virtue of the Schedule 1 deals by the session code. Okay, and those offenses less than 7 years, that can be dealt by the magistrate. Apart from this, now this is what the session, that is what the Schedule 1 has been discussed, and therefore, rather from the first day, I'm saying to all of you, Schedule 1 is the gist of the CRPC, which controls the entire CRPC. Apart from this, the section 9 of the CRPC deals with very important aspect, that is the power of the state government to establish the session division. And it's a rule that it is a duty of the state government to provide and to provide the infrastructure to establish the session division. Generally, district place is the session division, or there may be a 2, 3, 4 session division in one district. That is the power with the state government. Depends upon the pendings of the criminal cases. Depends upon the numbers of the cases. So that is not the part, but section 9 is most important. Now, once this establishment is there, as we have discussed by section 209, matter is again before the session court. It is committed. Once the matter is before the session court, compliance of section 207 is there, matter is there. Now, after the administrative work, it is allotted to the various judges. Now, why I am saying allotted? Say for instance, session matters, we have discussed the criteria of is 7 years punishment. There are some offenses, because while discussing the hierarchy of the court, we have discussed in session court, session judge, additional session judge, and we have discussed additional session judge and session judge. They are the equal. They are having the same powers. Next to the session judge, there is another category of the session court. We call it assistant session court, or sometimes we call it ad hoc. These courts, they are having the power up to the 10 years. That aspect we have already discussed. Sometimes the offenses which are not serious, like 498, 306, there are so many offenses. They are transferred to the assistant court session judge. This is administrative work which you are going to be understand when you enter into practice. This is not for the your examine point of view, but just to understand you people. Now, once this is done, say for instance, this we are discussing the murder trial, and now the murder trial is transferred to session court. Now, what is the procedure before the session court? My dear friend, my request to all of you: if there is a question on session trial, write down the session trial first. Your chronology should be, of course, we have discussed the maintenance question also. The first answer will be the session trial, and then to the maintenance question, so that the mentally you will be very happy that you have discussed the 30 marks portion. I'm talking about the old pattern, 80 pattern. Yet we are not aware which pattern we are going to follow, but yeah. See, 16, 16, 32 marks is a good deal, and that too very easy to write, because see, under the session trials there are only 13 stages, and within the fraction of second you can understand how, and therefore it's very easy. So the first stage, that is, because the first three stage is nothing to do with the accused person, that is the initial duty cast upon the prosecution. Now, at this juncture, I'm presuming that you are aware who is the prosecution, because since we are staying in the beneficial state, in administrative law, you might have been discussed. It is the duty of the state government to provide the help to the victims, and one of the help is that by providing the government prosecutor. to the victims. So it is not like a CPC that if you want to file a suit, you have to appoint your personal, that is a private lawyer. No, if the matter is, if the moment the police officer has FIR is registered, it is the public prosecutor who is dealing with the matter before the session court. Now, this public prosecutor play very important role here. We have discussed already. There is a hierarchy of the public prosecutor in under the CRPC, especially section 24, 24, 25. There is a director of prosecution at a state level. Then the public prosecutor, those who are dealing with the high court and the uh, high court and the session court, and then the assistant public prosecutor, those are dealing with the lower court. So since we are discussing the session trial, we are using the word public prosecutor because they are appearing in the session court. If they are appearing in the magistrate court, we'll call it assistant public prosecutor. Is that clear? So the first step, because the charge sheet is a bunch, huge bunch. Say for instance, in this murder trial, the police officer has recorded more than 50 persons, 50 witnesses deposition, and now the charge sheet is more than 300 pages. It's a bulky document. So the law is not expecting that on the first day itself the session court has to read all these aspects, and therefore the first section, that is section 24, I'm sorry, 225 to 26, that is the initial duty cast upon the public prosecutor. Section 225 is a one-line sentence. It says the session trial has to be open or conducted by the public prosecutor. In short, unless there is appointment of the public prosecutor to conduct the particular matter, the session trial will not be commenced. This has to be considered by the student. Now, once this public prosecutor has been appointed to conduct the particular matter, then next section came into picture. That's why I'm saying very easy to understand. Section 226. What is this? This is called as opening case by the public prosecutor. Now, what is this opening case? What is expected? The public prosecutor, it is expected from the public prosecutor that he has to read, he has to go through all the statements recorded by the police officer, all the medical evidence, all the other evidence collected by the police officer, the investigation officer, and he has to explain the gist to the session court before, I'm talking about before actually opening of the trial. What he has to say? Sir, these are the allegations we call as charge, which we are going to discuss later on. These are the charges against the accused person under section 302. And in order to prove the charges against the accused person, the police officer, after registration of FIR, they have collected all these documents, we call it the materials, statement, medical evidence, in order to prove. See, refresh your memory, we have discussed section 7, 8, 9, 10, 11 of the Evidence Act. To prove the intention, to prove the motive, they might have taken the identification parade as provided by section 9. There are so many things they have collected, and ultimately at the end of all these aspects, he has to satisfy the session court, sir, this is the fit case in which the honorable court has to conduct the session trial. Section 226 is very important. This is the opening door of the session trial. If the session court, after hearing the public prosecutor, my dear student, please bear in the mind, in this initial stage, accused person is not at all in picture. Of course, he is present in the court because it is mandatory he has to present before the court. If he is in jail, it is the duty of the jail authority either to produce, or nowadays he can attend by the video conferencing also, but his presence is required because again he can use the principle that is no one shall be unheard. So his presence should be inquired, except in certain circumstances that we will discuss later on in some lectures. But to these two stages, accused is nothing to do. First duty of the prosecution, that is the public prosecution, he has to satisfy the magistrate. Sir, we have complied section 207. What is that? We have provided all the copies of the charge sheet to accused person. And he has to show the acknowledgement. Either the accused has signed the on the charge sheet that he has received, or his lawyer might have received the charge sheet. And after reading this, if the session court, realize yes, there is something in the matter, then he proceed to the matter. But at the initial stage itself, please bear in the mind, he has not examined a single witness. Even the police officer has given the more than 100 witnesses. But after hearing the public prosecutor, if the session court realize there is nothing in the matter, to prove the initial charge itself against the accused person. This is just wastage of the time of the court. The court, that is the session court, can use his extraordinary powers, that is we call as the power under section 227, we call as discharge. Again, with the cost of repetition, I'm telling you, accused or his lawyer has not uttered a single word either under section 225, or 226. They have played nothing. They just keep mum. But after hearing the prosecution, after hearing the public prosecution, if the accused, that is the session court, realize there is nothing in the matter, then the session court can discharge the accused person. This is the extraordinary power, and this has to be done by the court without asking the single question to the accused person, without taking any evidence, just by hearing the public prosecutor, and that too after going through all the document filed in the charge sheet. But please bear in the mind, it has to be done in very judicial mind. It should not be hurried. Otherwise, this will be ground for the appeal by the public prosecutor. There is a provision for the appeal that we'll discuss when we'll be discussing the appeal from the discharge, that we'll discuss later on. So it's an extraordinary power to discharge at the initial stage itself. But at the stage of section 226 itself, if the session court realizes the prosecution and investigation officer has collected, or the material which has been collected by the investigation officer are sufficient to convict the accused person for the offences alleged against the accused person, or the lesser punishment, that is the discretion of the court, then instead of discharging the accused person under section 227, of course there are several case laws on this point. After this recording, you may go through the written notes, that is I'm going to send you on your group to all of you. That is the ready-made answer for you people, including the answer, that is the case laws. If suppose the court come to the conclusion that this is not a fit case for the discharge, then the session court will go to the next stage, we call it the framing of the charge. This is called as framing of the charge. Now, what is this framing of the charge? The topic of the charge, which we are going to discuss later on. Charge, we have already discussed. The definition of the charge is provided by CRPC itself. The real meaning of the charge is an allegation against the accused person. Now, what is the duty against cast upon the session court under section 228? After hearing the public prosecutor, he has to, now this is the first step, he has to call the accused person. He will call the accused person and he will ask the accused person. Of course, before that he has to realize whatever the investigation is done by the investigation officer, it is the fifth case in which he will conduct the trial, that is the session trial. That is session trial. It is triable by the session court, and then he will record the charge. Under this, he will call the accused person. This is the first time he will call the accused person, and it is the duty of that is the session court to explain in the vernacular language to the accused person, the language which the accused person understand, Mr. Accused, now the FIR is registered against you. Police has carried out the investigation. Now, in the case while committing the matter under section 209, you say you want to conduct the trial. This is not a fit case to discharge you under section 227. I am going to frame the charge against you. That is, on this day, charge, because one of the section of the charge says charge should be explained to the accused person in his language, the language which he understands, and what is to be included in charge? Charge is to be including all the details. That is, in crux. Suppose, let us take in this case, he has committed the murder. That is the charge. Now the charge should be in this manner. The session judge may ask the accused person, Mr. Accused, it is the police officer has kept charge against you that on this day, on this time, on this place, because time, place, and date is most important. Because if date is not matching, you are aware the accused might have taken the plea of alibi also, and therefore date, time, and place you have committed with the intention to commit a murder with the help of the knife. You have caused the injury to the accused person, and thereby you have committed the offence under section 302 of IPC. Now the next question is, that is to be asked by this is the mandatory. What do you want to say? Now here, this is called as the explanation of the charge. This is what expected under section 228 subclause 2 of the CRPC. It has to be explained that these are the charges. Otherwise, the accused might take the defense that I have not understood the charges against him. Therefore, it has to be explained to the accused person, not in legal language, but the language which he understood. Sometimes, if the language of the court and language of the accused is different, then court may take the help of the what do you call the person that is expert in the language. But it has to be explained to the accused person. And now, this is again interesting. After explaining the charge, the court has to ask accused person, these are the charges against you. Are you accepting your guilt? Now here are two things, and this is very interesting because now we are dealing with the session trial. Court has now discharged the accused person. The first stage taken by the court is that the framing of the charge. And if the accused person says, sir, yes, I have committed an offense. Now I will take the pause and I will go back. The provisions or the power of the session court under section 229 is different than the power of the magistrate under section 209. Under section 209, if you remember, we discussed while committing the offense before the magistrate, if the accused person accepts the guilt, but the problem is that offense is triable by the session court. But here, while framing of the charge, if the accused person says, yes, I have committed the offense, question is whether the session court can convict the accused person or not. Because here, there is no problem of the power of the court, because he is empowered. Now the word is used may. Please bear in mind. He may convict him, or he may, even after acceptance of the guilt. This is absolute description of the court. And on this point, we are going to discuss the historical case in India, that is we call it the Kasab case. You might have remembered when the matter of the trial of the Kasab is going on, and when the plea of the Kasab was recorded, he has accepted the guilt, stating that, sir, why you are taking the time, why you are wasting the money, and I am accepting the guilt, please convict me. But at that time also the court, by taking the advantage of the word may used under that particular section, he says, yes, you might have accept the guilt, but I want to conduct the trial. That is to call as the due procedure. That is a due trial. So tomorrow, no one can take, that is accused cannot take the help of the section article 21. That due procedure of law has not been followed. And therefore, most of the times, even the offenses that in I'm talking about the serious offenses, less serious offenses, the court may convict him. There is no bar to convict on the plea of guilt also. Otherwise, the legislature would have not made a provisions. But in order to prove the guilt of accused person beyond reasonable doubt, that is the principle under the Evidence Act. Even though plea of guilt is accepted by the accused person, court may prolong the matter. That is, they may conduct the trial. That this is the one of the aspects. Now again the question is whether this is again the judicial confession. The answer is may, again yes or no. That it depends upon the court again. That is how he has recorded. That is absolute discretion of the court. However, in under section 228, when the court asks him, are you plead guilty? Then if he says yes, then the court will convict the accused person under section 229 by using the power of section 229. That is the power of the court to convict the accused person plea of guilty. But if he says no, then next section came into picture. That is very interesting provisions made under section 230 of the CRPC, we call as date of the prosecution evidence. Now, see the criteria. Again, I'm going back. Public prosecutor has to be appointed, section 225. The opening trial by the session court, public prosecutor 226. 227, we have discussed discharge, that is if there is a prima facie case is not made out. 228, that is the framing of the charge. 229, we say that conviction on the plea of guilty. And if suppose the accused person say no, then the next stage is, it would have been directly the prosecution evidence, but the next stage is 230 deal with the date for prosecution evidence. Now why this date for prosecution evidence? See, during the investigation the police officer has examined so many witnesses, and therefore they have list of the witnesses. Say for instance, the person who recorded the FIR, witnesses, or the two person who has informed to the police station, medical officer, the neighborer. There are so many things that is we call as under the charge sheet, and therefore this section 230 says it is the duty of the public prosecutor to fix the date for the prosecution evidence. That is what he has to give. He has to give list of the witnesses which the prosecution is going to be examined. Now, why I am saying this? If you remember, under the Evidence Act also we have discussed. See, the quantity of witnesses is not important, but the quality of witnesses is required. And therefore, even the police officer has examined or he has taken the deposition of more than 100 people, but the prosecution, that is the public prosecutor, may choose out of 100, say 30 witnesses. And on this, under section 230, he has to give the list of the witnesses. That yes, even though 100 people's names are there as witnesses, I want out of that I want to examine these 30 witnesses. Now what is this? This is one kind of notice to the accused person, that so they can go through the deposition of the witnesses, and after going through the deposition of the witnesses, they will take the defense accordingly. Which question will be put to the witnesses? That is under the Evidence Act we call as cross-examination. How to deal? What are the lacunas? What are the contradictions? What are the additions made by the witnesses in a charge sheet while depositing in the court? And therefore, section 230 is most important. Since the session trial deal with the serious offences, this is the one chance again given to the accused person. Now, after the date of the prosecution, next date, it is the duty of the prosecution to examine his witnesses. That is the list as per the list given under section 230. Now they may, if suppose take for example, don't be an impression if 30 people's 30 witnesses name has been given, it is the duty of the prosecutor to examine all. No. Out of 30, they may examine 20 also. Then that is the choice of the prosecution. Depends upon the circumstances. When you enter into practice, you will realize. I will give the simple example. Don't write somewhere. But say for instance, in this particular murder case, the wife lost the complaint. She's a informant. I'm sorry, I'm using the word complaint, but she is lost the FIR. But when the trial is going on, she turned hostile. She says, "I don't know what is written in the FIR and all these things." Now, this is the case where, of course, only because the complaint or the informant hostile, that is not the ground for acquittal applicants, but the gravity of the trial is reduced, and therefore, the number of the witnesses also reduced, and the prosecution may take the witnesses that is under the charge sheet also, which are provided under the charge sheet. Here, the provisions section 137 and 130 of Evidence Act came into picture. That is examination of witnesses, cross-examination of witnesses, re-examination of witnesses, and everything has to be deposed under the CRPC. That is the deposition have recorded by the court and the steno in the court. Now, after the completion of the prosecution witnesses, next interesting stage came into picture. Say, for instance, 30 witnesses has been examined by the public prosecutor, that is from the prosecution side, to prove the guilt of accused person again, that is section 302, murder. But out of 30, the informant who turned hostile, there is no eyewitness, there is no direct evidence, everything is chaos. And prima facie, the court realized prosecution has failed to prove the guilt accused person prima facie itself. Then the session court has a power to acquittal the accused person by using the power under section 232. Now, here the word is used, acquittal. Please bear in the mind, before framing of the charge, it was a discharge. After the framing of the charge, it is acquittal. And this acquittal is equal to the final acquittal. Of course, right to appeal is there to the prosecution. But what is this acquittal? This acquittal, if the after taking the prosecution evidence, if the court realizes there is nothing in the matter, because no one has deposed in the court of law, prosecution witness, this acquittal is a failure of the prosecution machinery, that is the witnesses. Please bear in the mind. So the prosecution witnesses, they don't know what is happened, and therefore, instead of wasting the time, court may simply say the accused person, you are hereby acquitted the accused on the charge of murder. And at this stage, before acquittal, the court, it is the duty of the court to hear the prosecution and the defense also, whether to acquittal or not. And after hearing both the parties, if the court realizes that this is the fit case of the acquittal, then court can acquit the accused person. However, after the prosecution or during the course of prosecution witnesses, if all the witnesses or most of the witnesses, they have deposed that yes, we saw that the accused person has committed murder, and somehow the motive, intention, preparation, all these 4 stages has been proved by the prosecution initially, then and court has not acquitted the accused person under section 232, then next stage came into picture, we call as entering upon the defense, that is called as defense witnesses, section 233, that is after prosecution witnesses, and if the court has not acquitted the accused under section 233. My dear friend, before we're discussing this technical procedure, because after 6 months we are going to enter into practice, please bear in the mind, examining the defense witness is a dual sword. Sometimes, rather most of the times, it reacts toward the accused, because see the basic principle of Evidence Act. Basic principle of Evidence Act says, in the criminal trial, it is a duty, that is the burden of proof lies on the prosecution to prove the guilt, and accused person has to only disprove the contents of the prosecution. Nowhere it is mentioned that accused has to step into witness box and rebut the presumption. No, rebuttal of presumption by the accused person can be by either by showing the contradiction or variation by the prosecution witnesses. There is no need to accused person to step into witness box, and therefore, when you enter into practice, only because under CRPC 233 deals with the interim defense, that is not mandatory. The word is used may, because it's a double sword, and double sword means always it hit to the defense. Because because if suppose, say for instance, you the accused person step into witness box, and in cross examination by the prosecution something has been accepted by the accused person, then that will be called as admission, which has a greater evidential value, which has a very greater evidential value. And therefore, please take in, if there is no need, if you show confidence that prosecution has failed to prove the guilt, then don't examine the defense witness. But sometimes, as the accused person taking the defense, which are provided under section 96 to 106 of IPC, that is we call general exceptions. Say for instance, we are discussed while recording the charge, it is the duty of the court to explain on the day, time, and place. And say for instance, on while recording the charge, court says on 1st January 2022 at 10 o'clock you have committed the murder. An accused person came with the defense plea of alibi. He says, suppose murder is committed in Pimpri. He says, at that time I am in Delhi, and now he produced certain documents in the court of law. To prove the documents, to prove the contents document, he has to step up. In this case, he has to step up, and therefore section 233 came into picture. That is called as entering upon a defense. But it is not a mandatory again. He may come into the picture. Now, if suppose after the examination of prosecution witnesses, if the accused person is not acquittal and accused person is not ready to, and he says, no, I don't want to examine any witness. Next stage came into picture, and this is very interesting, which is not provided under the what do you call the session trial, but that is called as 313 statement. This is silent feature of the session trial. What is this 313 statement? This is some kind of the plea of guilt, wherein the court can take the gist of the all the witnesses, and he will call the accused person. He will ask the accused person, Mr. X, who is the informant, he deposed again this. Mr. Y, who is the mother, he deposed against you this. Mr. So and so, Mr. Doctor deposed unseen. What do you want to say? He may say not correct, not correct, not correct. Not. This is called as deposition under section 313. Now why I am taking this? Sometimes something has been accepted by the accused person under this 313 statement will be called as an admission. And therefore, when you enter into practice, while recording the statement under section 313, please take care that your client is not deposing or accepting guilt. Be careful. You should taught him what kind of answer he has to give to while recording section 313. Now, come back to the procedure. See, after prosecution evidence, he has not acquittal. Accused person say no, I don't want to examine myself or to by any witnesses. Next, and very after recording 313 statement, next and a very interesting statement came into picture, that is called as argument. Argument by both the parties. Of course, because the word is used, the prosecution shall argue. Whereas in case of defense, it is not mandatory, because if the prima facie the prosecution is not prove the guilt, the simply accused person says the prosecution failed to prove the guilt to a reasonable doubt. Once the argument before the court by both the parties has been over, next stage very interesting came into picture, that is section 235, what you call as judgment. Now there are two parts, 1 and 2. If there is an acquittal, if there is a acquittal of the case, then it is part 1, or if it is connected to part 2, that is depends upon the case. Now if the court come to the conclusion that prosecution proved the kill beyond reasonable doubt, then he convict the accused person. Now you know the punishment for murder conviction. And if the accused person, if the court realizes prosecution fails to prove the guilt, then court can acquit the accused person. Let us take the example in this murder trial. If the prosecution, that is the session court realized this case, prosecution has failed the case, and this case comes under the rarest of the rare case. Okay, so whenever he want to convict the accused person, before conviction, before pronouncement of the judgment, he has to call the accused person and he will say, now this court has come to the conclusion that you have committed the offense of murder and the prosecution has proved the guilt against you. What do you want to say? Now here there are two sections came into picture, section 325 and 360 of the CRPC. 360 deals with the Probation of Offenders Act, that we will later on discuss, and 325, that is the leniency has to be shown by the court. Now if the question is put to the accused person, of course the actual conviction has not been pronounced, but just court has asked the accused person, what do you want to say? Because it is duty of the court to take a pause for hearing the accused person. Then accused might say, sir, this is my first offense. Under unavoidable circumstances, I have committed this, and I am the only earning member in the family. Kindly reduce the punishment. Court may take consider in this aspect and might reduce. It's not to mandate on the court, and accordingly, court will pronounce the judgment that is called as conviction according to the matter. But apart from this, while awarding the conviction or acquittal, court has to take the previous record of the accused person. That is, we call it the character. Remember the Evidence Act. Character generally is not important. Section 58, we have already discussed. Unless it take as a defense. If the accused person says, sir, this is my first offense, and the prosecution produced a bunch of the charge sheet earlier conviction, then court may grant them serious punishment. So based upon the conviction, court may take, I'm sorry, court may convict the accused person or the release the accused person. This is all about the what you call the session trial. I hope this discussion is useful for you people. If you have any doubt, you may put down by sending me WhatsApp message, or you may call me at any time. Apart from this, I am going to send the ready-made answer sheet to all of you. It's quite lengthy, but I know there is huge gap between writing, going to the mind, and writing in the exam. So intentionally, I have made 16, 17 pages. When you get to your mind, it will be 16, and when you enter it, it will be 10. Along with case laws, introduction, conclusion, everything is ready-made. So don't worry. Within fraction of again 10, 15 minutes, we are going to next trials. Thank you.